Hello, good evening, everyone, and welcome to season 17 of Have We Got Planning News for You. Charlie will be here shortly, true to form. He's on his way to his hotel from the airport in a taxi, not a police car, so we should all be cheerful about that. As usual, if anyone wants to make a donation, we don't charge for the show, obviously, so please do have a look at our website, havewegotplanningNewsForYou.com, for a list of the charities that we support, or make a donation to a charity of your choice. I am absolutely thrilled to introduce two brilliant women to the show this evening. We've got Kathryn Ventham, who we're going to be interviewing in the second half of the show. Welcome, Kathryn. Where are you joining us from this evening? And please tell everyone what your theme for this evening is.
Thank you. I am joining from our office in Birmingham City Centre. Hopefully it should stay relatively quiet outside. And my theme this week is South Wales. I was going to go with Bon Jovi, but I thought that would make it too easy for Charlie and I and slightly harder for everybody else. So I opted for South Wales.
And why have you chosen South Wales?
Well, from my perspective, I grew up living in Nigeria and Singapore. And then when I had my teenage years, we then moved to South Wales. And as a teenager, I considered South Wales to be extremely boring. When you just, there was seemingly as a teenager nowhere to go, and I thought it was really dull. And actually now having got older and going back there with my parents still living there, I realised that actually rather than being really dull, it's actually really pretty. And I'm so sorry to South Wales for all of that. So that was why I picked my theme. So I have my son lent me his little cuddly bear for today. He's called Wales Bear. Very imaginative.
Super imaginative. Well, we'll see how the panel have done in respect to the theme. And the second person to introduce for her first show in this season 17 of Have We Got Planning News for You, Thea Hutton. Welcome.
Thank you very much, Steve. Good to be here.
Thea, tell us, who are you? Where are you from? Where are you joining us from? And then don't forget to deal with the theme.
Okay, who am I? I am Thea Hutton. I am a planning and environmental barrister at 39 Essex Chambers. I'm joining us from North London, from my home, but I'm originally from Norfolk. I'm a sort of proud East Anglia girl. I was asked to say a little bit about me. I thought it would be seriously boring to tell you about my practice, and so I thought, is there something more interesting I can share? And as I reflected, I came to the depressing conclusion that I actually peaked in life, aged 13, when I was awarded an international sporting cap, the sport in question being rounders, against Scotland, where England beat Scotland 42-2. So that's basically the pinnacle of the success I've achieved in life. And, well, everything's been downhill since then.
And the theme this evening, Thea, South Wales.
Yes. Yeah. I have raided my son's toy box and found a little Welsh dragon for you all.
There you go. Very well done. And Charlie, you've arrived. Welcome.
Hello. I am in Newcastle for the Mercury Music Awards. Unfortunately, I haven't been nominated myself, but nonetheless, it will be a rather fantastic evening. Sorry, I'm a little bit late. Got delayed on a BA flight, but at least I made it and stayed on the flight this time, so which is a positive. It's wonderful to welcome Thea. Thea, we're so happy to have you on the team, and also wonderful to have Kathryn here talking to us about flood risk, something that Kathryn and I have spent a lot of time together on over the last few months. My nomination for the South Wales theme, hope you can see this man here, you might see some strange Ukrainian wording and a picture of a Welshman, and you might think, what on earth is that? Well, in the mid-1800s, a man called John Hughes, who was from South Wales, from Merthyr Tydfil, and he ran a coal mining and ironworking company, and he got a contract to go to Ukraine, where they needed some help in that field. And he ended up founding my wife's home city of Donetsk, which under the USSR was known as Yuskova. They don't have the letter H in Russian or Ukrainian, so it was Yuskova rather than Yuskova. And to this day, the beer in Donetsk is called Yuz, Y-U-Z, and that's what the logo is. It's a picture of a 19th century industrialist, somewhat out of his comfort zone in eastern Ukraine. So that is my rather tangential link to South Wales. I could bore you to death about my business plan to bring John Hughes home and set up a John Hughes brewery in Wales, but I shall save that for another day. But very good to see you, Tora, and lovely to see you, Kathryn, and indeed the wider team.
Great, thanks, Charlie. Chris, we'll come to you next. Someone's commented that you're returning to your lockdown hairdo.
Yeah, that is because I suddenly had to do the school run at short notice, and I hadn't had enough time in hair and makeup before we started. So lovely to see everyone. Tora, welcome. And Monmouthshire, that's easy for me because my sister is a planning officer in Monmouthshire. So I asked her what it's famous for, and out came this: tourism, loads of holiday lets, big country houses subject to subdivision, equestrian enterprises, racehorsing, postmates, not stopping, just endless checklists, infrastructure, bus and hydrogen along the M4, and lots of barn conversions, single plots leading to disproportionate local objection based on self-interest. Family perspective there. So that's what Monmouthshire is famous for, if you're a planner.
Good stuff. All right. And Sasha, finally over to you, last but not least.
Yes, can I welcome Tora? I am in Dudley, so not that far from South Wales. Even my geography can get that right. I've got very happy memories of Monmouth because I was there cycling in 2020 when Arsenal won.
Dudley? How is Dudley near South Wales?
Well, it's reasonably.
I thought you said the M25.
London. It's bloody close.
Only someone from London would say that it's close to Wales.
That's ridiculous, Sasha.
It's very close. Anyway, I want to particularly thank Tora, and it's lovely to have Kathryn on.
Brilliant. Okay, and Sasha, I think we're over to you first for the news.
You are, absolutely. I've got 10 things I want to mention. We've obviously had a reasonable break since the summer episode. So the first thing I want to say is obviously, since we broke, the task force on new towns have reported. We've had the government's response, and I think it's worth identifying to everyone that the House of Lords Housing Committee are about to opine on that, and we're told that will happen early next week, so that's something to watch out for. The second matter, which is important, is the government's proposed changes to the Planning and Infrastructure Bill, which Charlie will know will engage him next week because it's going to be debated, as I understand it, in the House of Lords on the 20th next week. And of course, that aim is to speed up the process, make it easier for approval for certain large projects such as reservoirs and onshore wind. And it's important because the Chancellor, it's interesting how much respect the current government have for the planning system, because the Chancellor termed the planning system that we all love and work in as outdated. That's the judgment of the current Chancellor of the Exchequer. And there's also reconfirmation of the 1.5 million homes for the next 5 years. The third matter I wanted to mention is some good news that planning applications for new homes are up 68% from comparison with Q3 in 24 to 25. The actual figure is just shy of 100,000, 98,000 homes. And the cumulative total for 25 is just shy of 250,000 at 240,000. The fourth thing to be slightly sobering is the government have just released the rough people sleeping figures, and there are nearly 9,000 people sleeping in Britain every month. And that's pretty frightening that in 2025, a country of our wealth still have nearly 9,000 people sleeping rough. And that's sobering in the light of of where we are. The fifth thing is to notify that the Minister of Housing wrote a rather bizarre email to PINS. And I'm sure if everyone reads it, they're slightly surprised at what the intent is, but it's worth anyone involved in local plans to have this kind of, I think it's a bit of a jog on to inspectors, basically. Don't be so demanding, don't be so questioning. But if plans are capable of being allowed, let them in. The next thing I want to say is, which also relates to PINS, is they've now just released a checklist, which is highly material for those in the process of preparing local plans. They've got a checklist which is to assist those doing that. Seventhly, I think I've heard a rumour that others on this might corroborate that the government is also considering changes to the MPPF, and those might emerge in the relative near future. Eighthly, I think anybody involved in planning would like to know about Greenbelt, and it's valuable that the government have done a statistical record, and the Greenbelt only shrunk in the past year by 600 hectares. There are 13 million hectares, apparently, in England and Wales, of which 1.6 million is Greenbelt, so about 12% is Greenbelt. Also noteworthy, particularly this is for the CPRE, 11% of Britain is developed, apparently, according to the government. So when you hear swamped and overtaken by development, 11%, most people would not think is a figure that represents a swamping, frankly. The ninth thing, of course, is those that follow assiduously DCOs. Gatwick's Northern Runway got permission about 2 weeks ago. And lastly, this is just for Charlie. Shout out to Charlie. Next week could be quite an important week for him and his professional career, because the Supreme Court will opine on nutrient neutrality. So watch out for that judgment. So, Thea, thank you very much. That's on my news roundup for this week.
Brilliant. Thank you so much for that, Sasha. And tell me, is the case you're dealing with this week in the Greenbelt by any chance?
No.
No. I thought it would be with that summary, but thank you.
They don't have Greenbelt in Wales, do you? It's so close.
They have it in Dudley, though, don't they?
Well, we're going to hear from Paul Tucker next. We haven't kicked him off the panel. He's just somewhere doing something very important. So he's going to give us his case summary from a case in Epping.
So my case involves a decision of the Court of Appeal on the 1st of September 2025. It's a decision which quashed an earlier decision of Mr. Justice Eyre on the 19th of August 2025. And it was where Mr. Justice Eyre granted an interim injunction in favour of Epping Forest District Council to prevent the use of a hotel called the Bell Hotel in Epping to accommodate asylum seekers, pending the final hearing of an application for an interim injunction under Section 187B, alleging a breach of planning control from the use of a hotel to the use of the building to house asylum seekers, which the council contends is a sui generis use. The asylum seekers are housed under the duty to house destitute persons who are seeking asylum under the Immigration and Asylum Act 1999. There's a nice pithy description of the Secretary of State's duty in paragraphs 52 and 53. You will be aware of this case because it hit the headlines in August when there were significant protests outside the Bell Hotel as a result of the arrest of one of the occupants of the hotel, who was subsequently convicted of significant offences. But the case follows on from a series of cases in 2022, most notably Ipswich and Fairview, where Mr. Justice Holgate set out the questions whether or not there has been a change from a hotel use to a sui generis use as a result of housing asylum seekers is a mixed question of fact and law. It's very very fact specific. Mr. Justice Eyre concluded that whilst there hadn't been a flagrant breach of planning control, that because there had been a deliberate act on the part of Somani, their head contractors, who are called CTF, who have been contracted by the Secretary of State, and because of the surrounding circumstances, that he concluded that there was a possible breach of planning control, an arguable breach of planning control, and the balance of convenience under what are called the American cyanamide principles fell in favour of stopping the breach of planning control pending the final hearing of the substantive hearing of the 187B injunction, which is actually being heard this week. He also refused to allow the joinder of the Secretary of State to take part in the proceedings, the Secretary of State not having been served by the council and only finding out about it by informal means, and concluded that the Secretary of State wouldn't have been able to add anything to the matters which formed his judgment as to whether an interim injunction should be granted. The Court of Appeal took a fairly robust view and disagreed with the conclusions of Mr. Justice Eyre. Firstly, in relation to the issue of joinder, the Court of Appeal concluded very firmly that the Secretary of State would bring a different perspective in relation to the wider public interest and should have been joined. And the Court of Appeal was highly critical of the Council for not having properly serve the Secretary of State to enable that decision to take place. The Court of Appeal also concluded that whilst that Miss Justice Eyre was right that there had not been a flagrant breach of planning control, and whilst strictly speaking the decision to house the residents of the hotel was a deliberate one, which was the wording used by Mr. Justice Eyre, that nonetheless that there hadn't been the sort of circumstances that there are in other 187B cases, very often, for example, in gypsy and traveller cases, where one knows that there is a breach of planning control and there's the flagrant breach, or there's been previous enforcement proceedings or things of that nature, because there had actually been quite significant interaction with the council and CTF and indeed the Home Office before the occupation started. And this was the second period of occupation for the Bell Hotel. And during the time of the first period of occupation of the Bell Hotel by asylum seekers, there'd actually been an application to regularise the use by temporary application for planning permission for a change of use from hotel to sui generis, which the council had never determined, despite the fact that it sat on the books for a number of months. So the Court of Appeal concluded that the judge was wrong in relation to concluding that the balance of convenience favoured the removal of the asylum seekers pending the hearing, which, as I said, is taking place this week. Also concluded the judge was wrong in his approach in respect of the protests, and the protests having any effect upon the decision as to whether or not to grant an interim injunction. And one can see the logic of that as a matter of public interest, why the mere fact that people would be kicking up a fuss should not influence the question as to whether or not a breach of planning control should be withheld, albeit fear of crime is a material consideration. The court also rejected the submissions of Somani that there was an alternative remedy, which was in the enforcement notice and a stop notice, concluded that didn't preclude an application for Section 187B. So it's a case where the courts essentially said that the council didn't come to equity with clean hands, as the maxim has it. In other words, the council's actions could be criticised, that the Secretary of State should have been served and informed. And I understand from counsel in the case that's taking place this week, the Secretary of State is playing an active role in the substantive hearing of the final 187B. So although it's an unusual case for us to be reporting upon an interim injunction, it's nonetheless a very high-profile case. And the Court of Appeal's approach is one that I would commend to everybody. I think paragraph 127 of the judgment neatly encapsulates the Court of Appeal's thoughts in this respect. Thank you very much. Over to you, Charlie.
Or me. Thanks, boy. But we are going to Charlie next
We are, exactly. That's the neat little segue there.
Yeah. Take us to Brighton, which is...
I will. I'm going to take you to Brighton, which, just for Sasha's benefit, I've been on Google, and Brighton is 25 miles closer to London than South Wales is to Dudley. So it might as well be London. But anyway, I'm going to talk to you about a decision of the Secretary of State allowing an appeal by Barclays St William for a 495-dwelling mixed-use development on a former Gasworks site in Brighton, which was allocated for development. Now, despite the fact that the site was allocated, and despite the fact that it was, perhaps unsurprisingly in light of that, recommended for approval as a brownfield allocated site, members of the Brighton and Hove Council Planning Committee decided that they would refuse planning permission. There was a fairly lengthy inquiry in March in front of Inspector Dominic Young, and he recommended in fairly clear terms that the Secretary of State should allow the appeal and grant permission. He found there to be no harm to most of the many heritage assets debated at inquiry. He thought there was low, less than substantial harm to one listed building and a low level of harm to a non-designated heritage asset, the effect on which he gave limited weight. Slightly interesting reasoning in that part of the decision in relation to NDHAs. There were concerns about living conditions. They were rejected by the Inspector and the Secretary of State in agreement with him. There's quite an interesting passage in the decision documentation about the BRE guidelines being found to be non-binding, which is obviously correct. They are non-binding, but they're often cited against development on daylight and sunlight grounds. So that's quite an interesting passage. And the Inspector and Secretary of State found, in the context of the 1.7-year housing land supply that the council had, and the fact this was an allocated brownfield site, the package of benefits that the scheme would deliver would significantly outweigh the limited harm identified. Particularly interesting is the cost decision. The Secretary of State agreed with the Inspector that costs should be awarded, and the I think it's probably fair to say the inspector's findings in relation to costs were nothing short of damning. He found multiple instances of unreasonable behaviour. These included a failure by the council to review its case and take it back to committee in light of the new MPPF, a scant nature of the statement of case, very high-level statement of case, was necessitated intervention from the inspectorate for further and better particulars, over 10 weeks to respond to a draft statement of common ground, which necessitated an extension of time in that respect. He also noted that the inspector noted in his recommendation on costs that the initial response to the statement of common ground, as sometimes is the case, had lots of deletions, which then became uncontroversial in the inquiry. So what was the point of deleting in the first place? The inspector considered also that the council's objections failed to stand up to scrutiny, in particular a failure meaningfully to engage with the fact this was an allocated site on a brownfield land, and therefore there were a number of impacts that were priced into the allocation and couldn't therefore terribly form a reason for refusal. He found that the council had shifted its position in relation to heritage. There had been he said, a heritage harm argued at the inquiry to be a strong reason for refusal, but based on the minutes of the council meeting, it only got fleeting mention. And he considered the council had failed to weigh the harm to heritage against the benefits, as one must as a matter of law and policy. And he concluded by saying this, that had the council considered the application in an objective manner, I find it most unlikely that the application would have been refused. So very strongly worded, and that's not a criticism. If anything, it's a praise, actually. Criticism of the council for its overturn of a recommendation for this brownfield allocated site. And no doubt they will be picking up a rather hefty bill, which unfortunately taxpayers, rather than the councils in question, will have to pay, given the abolition of the surcharge, which may be something that ought to be reconsidered. Anyway, that's Brighton, and back to you, Thea.
Thanks very much for that, Charlie. Sounds like a pretty robust cost decision. For anyone in similar possession, have a read. It's unusual for inspectors to be quite so damning in their decisions, but thank you very much for that. And Tora, Matthew Pennycook's been busy.
He has, thanks, Thea. This is another Secretary of State decision, but this time a refusal. The appeal is the land at east of Hayes Drive, at 3 Mile Cross in Berkshire. The appeal concerned 148 dwellings and associated infrastructure, and the main issues were landscape impact, drainage, and the safety and well-being of future residents of the proposed development and the wider public with regards to the proximity of the atomic weapons establishment at Burfield and the future capability of the weapons establishment to operate effectively. So hopefully you can immediately guess which of those issues I'm going to focus upon. So what's the story of this site? Well, it's actually quite interesting because the application was refused by Wokingham back in 2024, went to inquiry, an appeal that wasn't recovered by the Secretary, called in by the Secretary of State, and the application was, or the appeal was granted by an inspector. That decision was subject to challenge by the atomic weapons facility. There was a consent to judgment by the Secretary of State and other parties. And so this was a rehearing of the appeal via a fresh inquiry. And just before the inquiry, the Secretary of State decided that he was going to take the decision, so recovered the appeal. The main parties were not only the council and the developer, but they were also the atomic weapons establishment, together with the MOD, and also the Office for Nuclear Regulation, both of whom objected to the proposal. So pretty strong opposition for the developer to contend with. So let's see AWE Burfield. I'll just ask that to go on the screen. You can see that there, facility broadly in the open countryside, which deals with essentially the making and restoration of nuclear weapons and their decommissioning. It has around it a detailed emergency planning zone, which you can see there on the slide. Ignore the red circles. What you can immediately see is actually there's quite a lot of population already within that emergency planning zone. But a policy within the local plan stated that developments would only be allowed within that zone where they can be safely accommodated, having regards to the needs of blue light services and the off-site emergency plan. So there was a host of detailed evidence from all the parties on the appropriateness of the site within the zone, the risk of an incident, the consequences of an incident, and the ability of blue light services to cope, and its implications with the plan. And one thing to note with regards to an off-site emergency plan is that the ONR, the Office of Nuclear Regulation, has the power to declare it inadequate. And the Atomic Weapons Establishment said if that were to occur, then it would seriously risk its ability to continue operating in the way that it does. So it was a very detailed case with regards to health and safety, but the key points which come out of the appeal decision are that everyone agreed that the likelihood of a radiation emergency was very low. But the Secretary of State found that even if that occurred, and even though a potential radiation dose was unlikely to be physically harmful, people might be anxious and worried about being exposed to radiation. It's probably true, and that would or may cause harm to mental health. If there were a nuclear incident, then the demand on emergency services and other public services would be greater than usual, and a greater population within the relevant zone would add to demand, and that would affect the off-site emergency plan, i.e. that additional population. There wasn't sufficient evidence before the inquiry that the plan and the emergency services could cope with the additional population. And the Secretary of State gave considerable weight to the ONR witnesses' evidence that the plan was under significant pressure, and that the appeal scheme would add significantly to that pressure. And you can now see on the screen the overall conclusion with regards to that issue of health and safety. So essentially substantial weight against the proposal for all of those reasons. Secretary of State then additionally considered the capability of the Atomic Weapons Establishment to operate effectively, and found that there would be an unacceptable risk of that, and found that the proposal was contrary to the relevant local plan policy TB4. Overall, on the planning balance, the Secretary of State, of course, found substantial benefits, as you'd expect, with 148 houses. Those are paragraph 39, but very significant or substantial harms, including the risks and the ability of the weapons establishment to continue operating. There was also some landscape harm, which was given significant weight, and then there was some less than substantial harm to a Grade 2 listed building. So overall, Secretary of State found a breach of the development plan, having looked at all those, and found that material considerations indicated permission would be refused, and also the tilted balance was outweighed by those adverse impacts. So I think it's a really interesting appeal decision, because when you start to look at the facts, you think, gosh, this is a really difficult case for the developer, but you do have to remember that it wasn't granted first time around. So a difficult case, perhaps an unsurprising decision once it was recovered by the Secretary of State.
Brilliant. Thank you very much for that, Tora. And we're moving just a little bit slightly north. And I'm dealing with an appeal in respect of a film and TV studio in Hertsmere. And this appeal also recovered by the Secretary of State in February 2025, shortly before the inquiry opened. And the inspector for the inquiry was Tom Gilbert Woolridge. And this decision was made by Matthew Pennycook on behalf of the Secretary of State. Now, the scheme here was recommended by officers for approval, but members disagreed and refused for two reasons, both of which concerned Greenbelt. And this was before the changes in national planning policy at the end of last year, introducing the concept of grey belt. Now, the council and the appellant agreed on a lot. There was a Rule 6 party. They agreed a little bit less, but everyone accepted that the site, which was approximately 15 hectares, was grey-belt. So despite this being a great big scheme, the inquiry was finished in 1 week of March this year, and the inspector reported to the Secretary of State on the 16th of June. The real dispute in this case arose over paragraph 155 of the framework, specifically A and B. And you'll recall that paragraph A, is there on your screen, asks whether the development would utilise grey-belt land and would not fundamentally undermine the purposes taken together of the remaining greenbelt across the area of the plan. And B is whether there's a demonstrable unmet need for the type of development proposed. Now, there's a bit of a spoiler here. B was pretty straightforward for the appellant. It was the Rule 6 party who resisted that point, but the scheme was promoted as an extension to the existing studios adjacent to the appeal site, which were already at capacity and had a clear need to expand. And the Inspector and Secretary of State both agreed with the appellant and indeed the Counsel on that. But as to A, I think that's really interesting, isn't it? Because it's such a high threshold, and it's really hard, I think, to conceive of much development that would fundamentally undermine the purpose of the remaining greenbelt in any area. And what the PPG says about this, and this was an issue at the inquiry, is that in reaching this judgment, authorities should consider whether or the extent to which the release of greenbelt or development of greenbelt land would affect the ability of all the remaining greenbelt across the area of the plan from serving all 5 of the greenbelt purposes in a meaningful way. So you're still looking at all of the remaining greenbelt, but unless the site is frankly enormous or performing some unique or special role in the greenbelt in relation to purpose C, for example, noting that you've already dealt with A, B and D to get there in the first place, I still think it's a really high threshold that won't be reached in the vast majority of cases. But I'd be really interested to see if there are any hypothetical scenarios that someone could come up with in the comments, or indeed the panel. Feel free to chip in on that. And what the inspector said about this at paragraph 14.7 of his report was that the assessment required by the framework, paragraph 155A, is not simply about percentages, as it is conceivable that the development of a small part of the greenbelt could still fundamentally undermine the purposes taken together of the remaining greenbelt across the plan area. Now, he didn't expand on that, and I find that decision takers haven't expanded on that, but he did go on to say that the PPG at paragraph 8 identifies the need to look at whether the development would affect the ability of all the remaining greenbelt from serving all of the purposes in a meaningful way, which indicates the need for a qualitative assessment. And then at 14.15, he said that the term meaningful way is not defined in the PPG, and it's possible that something small in scale, contribution or impact could still be meaningful. However, the PPG at paragraph 8 focuses on whether the development would affect the ability of the remaining greenbelt across the plan area from serving those purposes in a meaningful way, rather than whether the development would have a meaningful impact on the greenbelt purposes, because that's what the Counsel was saying. This is reinforced by the wording of paragraph 155A, which requires an assessment of whether development would fundamentally undermine the purposes taken together of the remaining greenbelt across the plan area. So the inspector concluded that the development wouldn't fundamentally undermine the 5 purposes across the remaining greenbelt, and that the development, which would generate £4.4 billion of gross value added to the UK economy in the next 10 years, including 3,827 direct jobs, would bring about very substantial benefits. On that basis, he recommended permission should be granted, and that was so whether the scheme was inappropriate development or required the demonstration of very special circumstances, or if the primary position that it was grey belt and acceptable development was agreed upon. The Secretary of State agreed with the inspector, found the proposals would not be inappropriate development, and also said if they were, there were very special circumstances anyway, and that ultimately the proposals accorded with the development plan. Some bloke, Tucker, acted on behalf of the appellant, so him and his team no doubt should feel very pleased with that decision, and well done to all of them. So that concludes the news and case summaries, and I'm going to hand over to Chris, please, to introduce Kathryn Ventham more formally and start your interview.
Thank you very much, Thea, and thank you everybody for those great case reports and the news as well. Sasha, amazing. You got so many points in. That is an impressive summary of what's been going on. So, Kathryn, welcome. Thank you very much for joining us. You started your career in local authority at Chiltern District Council. You then moved to the private sector and started working at Barton Wilmore. You became a partner there by 2012. And that, of course, has now changed to Stantec. You formed your own company together with some other directors from Barton Wilmore, Stantec, and you've been trading for the last 3 months. And you are also the mother of 2 boys, which is more challenging. Those 2, or all the barristers you have to face at cross-examination. What you have done is have, I think, very unusually, a very, very significant inquiry practice. You did your first inquiry, you told me, at 2011 in Stratford, when the council decided that they would take on objectively assessed need, and out came the Chelmer model, and we haven't looked back since, have we? Or didn't for many years. And you've gone on to do many, many appeals with many of us as well. And unusually, really, to see a woman doing so many appeals, such that I think we all agreed that you were the most prolific planning witness last year and this year as well, which is a real credit to your expertise and how good you are as a witness. I and the others have got questions about how you've done it and how you managed to build such a successful practice around being an expert planning witness. But before we do, the main topic for discussion today is flood risk, because people may have noticed there's been a change in the guidance in relation to flood risk. And so my first question is just that. What are the main changes to the PPG about flood risk?
Thank you very much for that, Chris, and thank you for a very kind introduction. And just as a starting point, I feel I do need to say I'm a planner. I'm not a flood risk consultant, as I was unfortunately listed on one decision earlier on this year, which Charlie found very funny. But the main change which has really generated the interest, and in a positive way, I really have to say, is the clarification on the interpretation of paragraph 175. And what that effectively now says is that firstly, you should take a proportionate approach to flood risk sequential testing, whereas previously it was kind of a, all guns blazing type approach to it. And probably really, really important is that if you've got a site-specific FRA flood risk assessment, and you can demonstrate that through layout and design, and really importantly, mitigation, that actually your site is safe from current and future surface water flooding, and you don't increase the risk of flooding off-site, that actually you don't have to then do the sequential test. And the important part of that is mitigation, because previously you were having to do flood risk sequential testing completely kind of devoid of any what I would call common sense approach, which is that there will be a drainage strategy in place and there will be mitigation in place. And that I think will hopefully have a huge impact. It'll stop us having to do sequential testing left, right, centre just because there is surface water on the site. We live on an island. It rains a lot. We are going to have surface water on sites. There's a couple of other sort of smaller ones in between. Perhaps not so small, but they've also specifically referenced what I call the Holgate balance. And it's not this technical term, but it's the balance which came out from the Mead Realisations decision, which effectively says it's not fatal if you fail the sequential test. It goes into the planning balance, and other matters such as housing need can also be taken into account. And then again, when you're dealing with, it also talks about when you're dealing with flood zone 2, flood zone 3 areas, if you've got large areas of an authority area covered by those designations, such as in the tidal authorities, coastal authorities, then actually if you need development in those locations to sustain it, you don't necessarily then have to search the whole area to try and find every single piece of land outside of that area in order to come forward. So for me, I think it's really, really positive. We're not quite there, but it's a huge step in the right direction and should massively cut down on an issue which spiraled out of control.
Yeah, because at the end of the day, this wasn't a problem before 2022. And then suddenly every puddle on site is a problem. And some developers like Richborough Estate said, look, we've got this on most of our sites. We've looked at our portfolio. it really was completely unworkable, wasn't it? And ridiculous. So how did you get involved in that then? Because you're, first and foremost, you're a planner and you're dealing with lots of cases, but obviously dealing with lots of inquiries as well. So how did you get involved in this?
In terms of my actual involvement to start with, my first involvement was I was involved in the Little Bushy Lane appeal. Flood risk not raised, or sequential testing not raised an issue at all throughout. The first we were over is we exchanged evidence with the council. I opened the council's evidence to see that we had allegedly failed the flood risk sequential test, with 4 weeks ago before the inquiry started. And so we dealt with that. We thought we had dealt with it in the inquiry. And then obviously the decision came out, which caused a problem. I mean, when we looked at it, and when you read the Bushy decision at first reading, what that effectively meant was that you had to rank sites across the district, and only what I call the gold medal site could ever come forward at one time in the face of phenomenal housing need. And we were like, that can't be right. So off we went to the court to deal with it that way, wrapped it up with one of Charlie's ones that he was dealing with Mead. And at the same time, I was also dealing with Hutton, which has obviously had its decision now out as well. So obviously, having kind of been involved right at the start, since then, what I've also been trying to do is really work to get the issue again back under control. So I've had meetings with the EA, had meetings with MHCLG before the PPG was drafted. Obviously, discussions with yourself, discussions with Charlie and Zach and others who are also really close to the issue. Again, just to try and look at how we could get some better wording in there. Sam Stafford delightfully roped me into a tour of all the HBF regional events last year so that we could just go through and just understand the scale of the problem, because there was a point at which if you knew it was a problem, you really knew it was a problem and you were being affected by it. But there were still huge areas where actually people had no clue that it was an issue. And we were like, no, it's coming your way. You need to be really alive to it. And then, at the same time, working on the appeals and working on the cases again, just to try and, at that point, the Mead realisation judgment had come out, and obviously then working on the appeals to try and implement effectively the Holgate balance and try and get some decisions out which reflected that.
Well, it's not like one of Charlie's cases to influence what happens to everybody's day-to-day life, is it?
So the Holgate balance, by the way, I told David that there was such a thing as the Holgate balance, and he was quite pleased.
Yeah. I don't know what that means. In terms of the extent of the problem, how extensive was this for the industry?
As somebody who was I was getting questions on a daily basis about it. It really was an issue. It started off as sort of a very localized issue, and then almost as people became more and more aware of it, then the issue became bigger and bigger. I think somebody I worked with said, he was probably quite correct to use the term. It became weaponized, for want of a better term, at one point, and it was just literally like, if we've got nothing else today, we'll add on sequential testing as well, just because we can. I think the LPDF did a survey last year, and I think that was only a survey of 20 members, but that showed some 57,000 homes were held up by it. Now, if you think that was only 20 members, it wouldn't have picked up probably a lot of SMEs and things like that. So it really was a problem. And the problem you have with sequential testing is almost bigger is better. The smaller your site is, the harder it is to do it, because your pool of sites to assess is just so great that actually when you get down to the really small sites, particularly for SMEs, it's really hard to do. And so I know clients who walked away from it last year and maybe in 2023, walking away from what I would say were perfectly good sites, other than there was just a nervousness about the sequential test, how you dealt with it, and actually, this was again pre-Holgate, but actually how you would go, how on earth, out of the hundreds of sites in this district, how on earth do you get to demonstrate that you are the top site?
Yeah, that's really interesting, isn't it? I hadn't thought about that it actually prejudices SMEs and smaller developers because, of course, they had smaller sites. So then you could look in a much wider context. So, okay, we've got some changes and everybody's happy and pleased and delighted, I think, with some of those changes. But what further changes in relation to the sequential test would you have liked to have seen?
There are a couple. I mean, I am so grateful to everybody that's put in the effort to get us to where we have been. I'm super grateful to to the government for kind of making those changes and understanding the problem. And so I am fully aware that probably that's it now as far as the issue goes. So this is what we're going to have to work with. I think, whilst I appreciate the flexibility that's been introduced with the words like proportionate, pragmatic, I also can see myself on a stand at some point debating what do those words actually mean. What's proportionate to me is not going to be the same as proportionate to somebody else. What I think is a pragmatic approach, somebody else will say is unduly restrictive or something like that. So I can see some debate coming about those words. And that's, I think, linked to the fact that one of the points that Justice Holgate picked up when we were in court was there is no kind of established methodology for carrying out a flood risk sequential test. And he said, it's incumbent upon MHCLG really to write one. And we have kind of previously written one, we've supplied it to them. But it does create problems. And I think my biggest bugbear, and one I can talk for hours on every inquiry is actually, what does reasonably available mean? And that's because from it says land shouldn't have to be owned by the applicant to be reasonably available. I fully get that. But in my view, reasonably available should mean reasonably available to the applicant, because land in this country is owned by someone. If the answer is it can be reasonably available to anybody, then you are creating a test which in my view is impossible to pass. And one of the inquiries that Charlie and I did earlier on this year, that's exactly the view the council took. They said for residential, it should be impossible to pass the sequential test, and therefore reasonably available should mean reasonably available to anyone. And that would have been my big thing. So I would have just liked to have seen some clarification on that. But
yeah, because although we're all excited about surface water having been dealt with differently now, we've still got it in many other areas, including groundwater as well. And
Coasting.
Okay, so what are we meant to do now?
Where do we go? So, I mean, I'm firmly in the glass half full camp. What we have now is better than what we had. And, I make no bones about that. It is far, far better, and it will massively reduce the amount of sequential testing work that we've done. Are we back? I think you said earlier, are we back to where we were in 2021? No, we're not. But are we where we were last year? Equally, no, we're not. We're not testing for every bit of surface water on site. In reality, the issue now is, as far as surface water goes, I'm afraid I've passed the ball now to the proper flood risk consultants. It's over to them now, effectively, which is what they were doing anyway, but to demonstrate that the site does drain, that it doesn't cause problems off-site elsewhere. I mean, personally, I've not put applications in where that hasn't been demonstrated anyway. So, it's just a case of going, actually, it's sort of pushed that bit sideways. What it doesn't mean, and this was my sort of, everybody got very, very excited when the changes came out. What it doesn't mean is it's done away with the issue. I was looking, going, I've had five potential, either current or potential instructions since the PPG changes came out. And I was looking at them going, I've got one in relation to an appeal, one in relation to a flood zone 3 site, one in relation to off-site highway works in relation to flood zone 2, a potential back pocket one because there's still a little bit of nervousness about it, and then one related to groundwater as well. So it's not gone away, but it's definitely better than it was. So if you're just dealing with surface water, then in reality, I was going to say you should be home and dry, but that literally you should be home and dry.
Yeah.
Your homes also should be dry. So
I think you could do more of a Gladman Faversham, where when they're brave enough to not do it, you go, yeah, there is some surface water. The engineer says you can solve it, and actually should be brave enough not to say, I'm not going to look at the whole of the district. Yeah.
And I think we will get there on that. I think, that my view is that the what I call the back pocket ones, I think that will hopefully just disappear. I think it's probably just the final couple of those, and then I think that will go away.
Okay, great. Thank you very much. I have got one more question, but I'm very conscious of the time. And so I'm going to open that up to Thea and ask for your question.
Thanks, Chris. And hello again, Kathryn. My question for you is, we've spoken about, a relatively small change to the wording of the PPG that's had a big impact. And are there any further changes to the PPG, non-flood risk related, that you would like to see that you think could make a similarly large impact?
Yeah, I think for me, this is obviously the PPG is a massive document, covers a huge amount of topics. I think for me, I would like to see a greater emphasis, I think, on forward planning for later living and integrated retirement communities. So many of those that I get involved with are spec applications, or spec sites, should I say. We all know that it's very hard for that industry to then compete with the house builders on price and therefore, on land. So I think I would like to see some changes for that make a greater emphasis on positive identification and allocation of land for that, and not just the kind of 5% of 5% on big strategic sites or whatever has to accommodate that. So that's what I would really like to see, along with maybe some clarification on actually what is kind of later living integrated retirement communities, because every time I do one, I feel like I have to go into the council and actually explain what it is I'm trying to do in the first place. So I think some clarification on that, and then a kind of wider issue just in relation to some kind of incentivization, or in terms of kind of proper timescales for responses to planning applications from stat consultees. But that probably links to Charlie's question later that he's going to ask me as well.
Well, you can save that answer for Charlie. You, Kathryn. Cheers.
Thank you, Thea. So next, Sasha, please.
Thank you very much. Kathryn, can I ask, in the benefit of hindsight, would you still go into a career in planning or not?
So I didn't choose planning as a career to start with. I did a geography degree, and then I was in South Wales at the time, within walking distance of Dudley, and I was there, and I couldn't decide whether to go left and do politics at Bristol or right and do planning in Cardiff. And going to Cardiff didn't involve paying the toll to go over the Severn Bridge every day, so that is my genuine reason for picking planning. Yes, I would pick it again. It has, as every career, has its days where you just think, oh, never again. But there's something about planning which I love the variety. I love the fact that I can do 5 different things in one day, and just with the way that my particular brain works, particularly with inquiry work, there's just something about it which clicks. So yes, I would pick it again deliberately this time.
Thank you.
Really lovely. Well, lovely answer and great question. Okay, Tora, your question then, please.
Thanks. Thanks, Chris. Kathryn, it really follows on from that, because you obviously have a love of doing inquiries. You're obviously very, very good at it. I think we often come across planners and other professionals who are sort of terrified of getting into a witness box. What would you say to someone who's a bit nervous about it but wants to progress in their career? How would you advise them?
Yeah, I would say the nerves don't go away as a starting point. I still get incredibly nervous the night before, the 5 minutes before, so they don't go away. I would say do take the opportunity. It is rewarding. It's really nerve-wracking, but actually when you come off the stand, the kind of buzz and the high is also kind of worth all the nerves before. I would say gradually, try and gradually build up to it. If you can, start off maybe by speaking at planning committee. If you can answer questions from members, then it's pretty good going for being able to, do it on the stand. Go to consultation events. And then, I always say to people, so whenever I have, sort of people helping me on appeals, I always get them to do the condition session and the 106 session. It's a really good way of being involved. You get to liaise directly with the inspector, answer their questions, work with the other side, but actually you've got people around you, so you're not on your own effectively. So I always say that's a really good way of doing it. And also you get your name on the decision notice, which, speaking to members of my team, they said it's a real, they love it when a decision comes out, they win, and actually they're named on the decision notice. And I'd also say, if you're going to help somebody at an inquiry, which I think you should really do, and I really do think it's incumbent upon kind of directors and senior directors, etc., to make sure they take people with them to inquiries, to let them watch, to let them get the experience. And I would say, if you're given that opportunity, really make the most of it. Read the evidence beforehand and make yourself integral to the team, so that actually you're not just sitting there going, oh, it's fine, I'm not the one giving the evidence. Know the evidence, and so when somebody on the WhatsApp group is going, where can I find this? Then actually the answer to where that is, because it then gives the clients that are there the confidence that actually next time around you may get your shot as well. So really kind of, it is opportunity led, and if you do get the opportunity, definitely take it, but build up to it by doing EIPs or things like that first.
Brilliant advice, thank you.
I think that's so true, isn't it, about the junior people assisting you, the grad planners and the associate directors, and I've seen people just suddenly come up with the answer and impress the clients because they know that. I also happen to know that you are phenomenally well prepared. I see your notebooks covered in post-it notes, covered in things. You're just phenomenally well prepared, but then show me a professional woman who isn't well prepared. Okay, last but not least, and we are delighted that you made it off your plane. Rolly.
Thanks very much, Chris. Hi, Kathryn.
Hello.
Thank you so much. What brilliant inspirational advice for budding future inquiry witnesses you've just given. Thank you so much. Well, so many things I could ask you. I was very tempted to ask you about Bon Jovi, given you're the one person who likes Bon Jovi more in the planning sector than me. But I shan't. I'm going to ask you a serious question about what I call the whack-a-mole of planning. There's always something that holding things up. There's EIA and SCA, then it was nutrient neutrality, water neutrality, flood risk. Maybe that's resolved, maybe it's not completely resolved, but certainly it's more good than bad. Absolutely an improvement. What now, in light of surface water in particular having been ostensibly resolved, what do you think is the biggest single blocker to the government delivering its 1.5 million homes that it wants to deliver by the end of the current parliament?
That's a big question. Everybody I met today asked them. I was just like, this is a really big question. I mean, it's probably come from like where personal experience at the moment, but as somebody who does a lot of housing schemes, and I've got applications currently, I would say funding and resourcing to councils, but in particular, statutory consultees. I know there's a dearth of planning officers, but for me, it's from a personal perspective, what is holding up my planning applications at the moment is statutory consultee responses. I've got applications where I've agreed with the case officer that agree about all the kind of issues sorted, but I can't go anywhere because I don't have an LLFA response or an ecology response or a highways response. So I would say, in terms of kind of out with the kind of really big ticket items, so much of our housing delivery is through, they're not small sites, but, is through that kind of, 100 to 500. That's a lot of what keeps the machine turning whilst the bigger ones take their time to come through. And that's for me as a real blocker to the kind of the day-to-day sites. And I was actually thinking about it this morning, and I was thinking, I had a meeting with somebody this morning, a case officer, and she was like, we're on 13 weeks as today, we've now extended the time. I can't tell you when your highways comments come through. Absolutely no clue. She was like, and I'll tell you that it's the same for ecology as well. And the other thing that struck me is that a lot of them are being outsourced. So in this instance, both of those disciplines are being outsourced, but they don't seem to have any way of holding the people that they're outsourcing to account. So, she was saying, I'm emailing the person that we've outsourced them to. They're not replying. We're not getting anything back. So it's a slightly odd one that it's all being outsourced to, in some instances, to consultants, but then they're not able to kind of get anything, any responses from the consultants, arguably any quicker than they are if they were doing it in house. So there are, lots of things. There's the, JRs, et cetera. But for me, that, I've just seen somebody now say wastewater. Yes, that's another one. But for me, yeah, that's the thing. There's so many. But I think it's probably, mine's just coming from the meetings I've had today, to be honest. But I think, in terms of trying to keep the machine going and keep that kind of supply of sort of quicker delivery sites going, then yeah, for me, there's just a real issue in terms of stat consultees at the moment.
Thank you. Maybe because there's a consultation, I think, isn't it, all about to be launched on trimming statutory consult. Penny Cook spoke about it yesterday. Yeah. Maybe it will help things in the right direction. Yeah. But thank you for that. Back to you, Chris.
Yeah, thank you very much. I think that consultation is due soon. Let's hope so. They consulted about it in March, didn't they? So let's hope we see that. I think a whole different approach to statutory consultees, not just 2 or 3 of them is required, isn't it, really? Yeah. Well, thank you very much indeed, Kathryn. Wonderful insight, both into the issue we were discussing, but actually more broadly, your whole career, and encouraging others as well. That is very, very welcome. Thank you ever so much. And back to you, Thea.
Thank you very much. And just so how engaging that was, Kathryn, the chat's just blown up. Response to your last answer. And I don't know any guest that's actually been reading the messages coming up while also giving their interview, which is doubly impressive. So thank you. So I shall tell everyone that our next episode is on the 30th of October, and I'm super excited for this one because we've got Chris Boardman coming on to talk to us in that
gold medalist.
Yeah.
Gold medalist.
I can't compete with that. That's fine.
It's good. You don't have to, Kathryn.
It was only Tora who was hoping to compete with Chris Boardman.
Tora's going to bring her around his bat. No rounders. It's not going to be on the velodrome, unfortunately, but it should be a really good episode anyway. So don't forget to join us for that. And also, if I can remind you, please, to subscribe to our YouTube channel and or follow the podcast on Spotify or Apple or wherever you get your podcast from. Thanks very much for joining us this evening, and see you all next time. Thanks again, Kathryn.
Halloween. Thanks, Kathryn. Bye-bye.
Thanks all.